Hi, I'm Tom Vanderblumen. I'm a trademark and franchise lawyer in South Carolina, and here with a recap of our January 9, 2026 newsletter, where we talked about the Marx Brothers and the public domain, baseball trademarks, and common law trademarks. We also had a trivia question about a cartoon dog from the 1930s. If you're interested in the newsletter and seeing the trivia question and maybe even a picture of our beloved law clerk, see the link in the description. So what do the Marx Brothers have to do with copyrights and the public domain? Copyrights don't last forever. After a period of time, the copyrights will expire and the works will enter the public domain. That frees up books and movies and art and music that were previously protected by copyright law. Every year, a new list of well-known works becomes part of the public domain. And this year's list includes a Marx Brothers movie with a great scene about dictating a legal letter, plus some other classics like the Faulkner novel As I Lay Dying and the original movie version of All Quiet on the Western Front. Copyright terms can still be pretty lengthy, and the rules for calculating them can be a little tricky, especially since the law has changed over the past 100 years. Copyright law has actually been around for a long time, and the U.S. Constitution, which was written over 200 years ago, even mentions copyright principles. Duke University's law school has a Center for the Public Domain, and it tracks these kinds of things, and it has a handy chart for calculating the copyright term. We will include a link in the description. What you'll see is that works first published or registered in the United States before 1978 and timely renewed can enter the public domain 95 years after publication or registration. So, if the publication year was 1930, the 95 years would run out in 2026, meaning we are looking at many popular works from 1930 coming into the public domain now. One of those is a Marx Brothers movie called Animal Crackers. We like it because we like the Marx Brothers, and because they frequently make fun of lawyers. And you can see this in the scene where Groucho's character dictates a letter to his lawyer, the Honorable Charles H. Hungerdunger, in care of Hungerdunger, and McCormick. Make sure not to leave out a Hungerdunger. In the letter, now I won't do an impersonation of Groucho Marx because I don't have a cigar or eyebrows like he does, but he says in the letter to his lawyer, i.e. to wit, e.g. in lieu that, despite all of our precautionary measures which have been involved, we seem to believe that it is hardly necessary for us to proceed unless we receive an ipso facto that is not negligible. You can see a link to the clip in the description below. Do lawyers still write that way, 95 years later? We wonder what movies we'll be talking about in 2121, 95 years from now. Let's talk now about baseball trademark season. It may not be baseball season per se, but baseball has been popping up in trademark news lately. One case involves the Las Vegas Athletics, or at least the soon-to-be Las Vegas Athletics, as they are planning to move there soon. The other case involves New York Yankees' Aaron Judge. You may have seen that the Athletics encountered some pushback from the U.S. Patent and Trademark Office on their effort to register Las Vegas Athletics and Vegas Athletics as trademarks. What's going on there? The USPTO refused the applications because it believes the term athletics is generic for apparel and baseball-related activities. The examiner says the term means activities such as sports and exercises and games that require physical skill and stamina, and is used to refer to a type of clothing worn while performing sports activities. Trademark lawyers might, at first blush, suspect that the Athletics' long-time use of the term athletics, with the club's history including as the Oakland Athletics, the Kansas City Athletics, and the Philadelphia Athletics, would lead them to be able to register the marks. After all, the team has already registered many of those other marks, including a logo that uses the term athletics. Other registrations and long-time use of a term can support a claim that that term has acquired distinctiveness and become a trademark. For now, the U.S. Trademark Office has been unmoved, finding that the team's prior registrations are not the same as Vegas Athletics and Las Vegas Athletics, and instead used other cities' names. The examiner says that the public does not always associate the same name with one team, and gave examples like the New York Giants, as opposed to the San Francisco Giants, the St. Louis Cardinals as opposed to the Arizona Cardinals, the New York Rangers as opposed to the Texas Rangers, the Carolina Panthers who didn't fare too well in the wild card game recently, versus the Florida Panthers, and the Sacramento Kings as opposed to the Los Angeles Kings. The team still has plenty of trademark rights surrounding their use of the athletics term, including with those logos, so they probably won't be too held up by this. Let's talk about another recent baseball trademark case, and this one involving Yankees outfielder Aaron Judge. Last week, a federal appeals court affirmed his successful opposition preventing a Long Island man from registering trademarks for "Here Comes the Judge," "All Rise," and a judicially themed baseball logo. Even though Judge had not previously registered these terms himself, the USPTO concluded, and the appeals court agreed, that he had sufficient common law trademark rights to prevent someone else from registering them. The Long Island man claimed he did not know about Judge's use of these judicially themed terms, but the trademark office found his timing, choice of marks, and colors were eyebrow-raising, and basically the trademark office didn't believe him. The trademark office decision explained how Mr. Judge had common law rights from his prior use of these types of judicially themed terms, even if they had not been registered. As one example, it pointed to how there's a section at Yankee Stadium called the Judge's Chambers. This is a section 3 rows behind where Mr. Judge plays in right field. 18 fans are given black Judge's Robe t-shirts with his number 99 on the back, and each gets a foam gavel with "All Rise" on it, which they can take home. It's probably a good idea that these are made out of foam, just in case things get out of hand. This case is a good example of how an application to register a trademark can be opposed by someone else who has common law rights from using the trademark, even if they did not previously register it. If you find this kind of content interesting, or at least not repelling, and you'd like to sign up for our newsletter, see the link below. At a minimum, you might want to see the trivia question and the pictures of our law clerk, who is almost recovered from the holidays. We hope you enjoy.